group of Canadian news outlets, including CBC, Radio-Canada, Postmedia, Metroland, the Toronto Star, the Globe and Mail, and the Canadian Press, has launched a joint lawsuit claiming copyright infringement by ChatGPT creator OpenAI. Lawsuit was filed in an Ontario court last week. Apparently, these companies are looking for punitive damages from privately owned OpenAI, along with payment of any profit the company made from using news articles produced by these organizations. It wants an injunction preventing OpenAI from using their news articles in the future. We're joined by Sana Halwani, a lawyer with Lenzner Slatt, who is representing the media companies. Thanks very much for coming on the show.
Thanks for having me.
Could you describe, we've heard about this, the New York Times has taken similar action. Tell us what these media companies say OpenAI is doing before we get into the actual complaint, if that's okay.
Absolutely. So there are really two parts to this. And so as you sort of summarized in your introduction, the media companies are alleging that OpenAI has been scraping deliberately huge swaths of data from the websites of these companies to use to train its GPT models. And in doing that, it's doing it without consent or authorization. And so really, from a legal perspective, what we're saying is that this constitutes both copyright infringement and also is a breach of the terms of use of the websites of these companies.
So, for example, and this is just hypothetical, say I was to ask ChatGPT, does Donald Trump have any charges pending against them? The allegation here is that ChatGPT would go to the New York Times archive and look that up.
Well, so, I'm not the tech expert here, but my understanding is that what's happening here is that there are two different types of uses of the content on the website. Both of them are being accused in our claim. The first is this sort of wholesale grabbing of all of the content from these websites, and then that is used as data to train the large language models. And the other aspect is what's called RAG for short, which is really that sometimes what happens when you prompt GPT or chat GPT, it actually goes to the website of a particular entity, like one of these media organizations, and it grabs information from that website sort of in real time. And both of those types of activities are being alleged to be infringing in the claim, both, again, under copyright law and contract law.
Now, apparently, my limited knowledge of copyright is it applies to the form of words, but you can't necessarily copyright news. I mean, it's unethical to probably report news without citing the source. But is ChatGPT clearly in violation of copyright here?
Well, we say, of course, that it is, or we wouldn't have brought the claim.
No.
And really, it is about the copying of the work. So to be able to actually train the LLM models, as the claim describes, this scraping constitutes copying. That's one aspect of the copyright claim. And then another one is that we allege that OpenAI has been circumventing what we call circumventing or breaching technological protection measures. That's sort of fancy words for things like logins or paywalls to be able to access this content. And so all of that is under the Copyright Act and is in violation of the Copyright Act.
I see Lisa Macklin, who is a lecturer at King's University College at Western in London. She's quoted as saying, there is no copyright in facts. They would need to prove that the OpenAI's output has substantial similarity to their existing publications. I know I'm asking you the same question here again, but there's no actual copyright in facts. So does OpenAI have an out there, a defense?
Well, our claim is actually not based on the outputs. It's based on the inputs. It's based, again, in the copyright context, it's based on the accessing and copying of the content to train the LLM, and in this case, that's GPT.
Now, OpenAI is quoted as saying here, we collaborate with news publishers, including in the display, attribution, and links to their content in ChatGPT search. Is there any truth to that? Have they tried to work with news providers?
I can't speak to that, but I can tell you that what they have been doing with respect to the news media organizations that are involved in this claim has been done without any authorization, without any consent, without any compensation.
Oh, I see. I see. So they have not offered compensation. Have they even reached out, though, to the news organizations that are involved in the case?
I can't speak to that.
Right. But there's been no question of compensation or crediting, as far as you know?
Well, so crediting wouldn't be a full answer in any case, but again, there has been no authorization, there's no license in place, there's no agreement in place between OpenAI and any of these companies. So all of this activity that OpenAI has been undertaking with respect to the companies that are the plaintiffs in this case has all been done outside of any kind of, legal allowance to do so.
Right. And this, sorry to harp on this, this is a straightforward copyright infringement case. It's as though I took a novel and I published the words under my own name, in other words.
Well, the copyright claim is based on very straightforward, I would say, copyright principles, which is that you cannot copy and use information, or you cannot copy and use a work. That's the language we use in copyright law. Sure. In the way that they have done so without permission. So, here they've taken, or OpenAI has taken, entire works, millions of them from these companies, and use them for a commercial purpose. And that is entirely outside of what's allowed in copyright law in Canada.
Just remind us, we've heard of the New York Times, we've heard of cases being brought in the United States. To your knowledge, have other cases been brought around the world?
There are, I think, I don't know about all of them, but we do know there is a number of cases that have been brought in the United States and in other jurisdictions. As far as we know, there isn't another case that has been brought in the same way as this, for example, and by that I mean by the leading news media companies of a country that have banded together. We're not aware of any other claim like that. The other aspect, again, of this claim, it's not only based on copyright principles, it's also based on contractual principles, breach of contract of the terms of use of the websites. And the New York Times claim, for example, doesn't include a breach of contract claim.
It is interesting, isn't it? A whole emerging area of law with these generative AI programs.
Well, certainly we haven't seen any real precedent or a substantive precedent when it comes to these kinds of allegations relating to training of LLMs or anything like that. But in our view, really, we don't need anything other than sort of basic copyright principles and basic contract principles. The activities that they are doing, the scraping, the training, the using all of this content that has been made with blood, sweat, and tears by the media organization, all of that is really just sounds in basic copyright and contract principles.
And it is interesting because these generative AI programs are not really speaking; they're just imitating what they see said elsewhere.
Well, yes, as I understand it, it's really kind of a probabilistic way that they generate their answers. It's based on these large sets of data. But again, I am definitely not the technical expert on how all of these work beyond what we needed to know to be able to understand and pull together the claim. And
I better watch myself there. I talked about that expert at Western. She was quoted in a CBC article, so I better keep myself on side there. Yeah. Amazing. And so the damages, you're looking for punitive damages here.
Well, so we're looking for, I think, again, you said in your introduction, we're looking for I should say, there are a large number of ways in which the damages can sound in a case like this. All of them have been pleaded. At this point, we don't know exactly which way the court is going to go, sure, and we certainly can't quantify them. You're correct. We have included punitive damages in the claim, and that's because, in our view, all of this has been done in a knowing fashion, in a willful fashion by OpenAI. As the claim sets out, they have entered into.
I'm sorry, Sana.
No, that's no problem. Thank you so much for your interest.
Sana Hawani, lawyer representing media companies suing OpenAI. Thanks for watching The Close.